Legislature and Gohan is called to order. I'd like to ask Senator Yamashita if he can lead us in prayer.
I think oftentimes we don't realize the importance of the leadership that we have in here to drive towards peace. The work here in terms of priorities that will help each of our people access opportunities, to define the priorities through funding, through deliberation, to what is best for all of us. It is through our work as we drive towards peace that determines policy, that we drive programs and priorities and practices. The work of this hall is so significant, and we thank you for allowing us to be your peacemakers as we do what you believe is best for our island, for all of our families. We wish everybody a blessed Christmas, a safe and prosperous New Year.
Thank you very much, Senator. Senator Morrison, if you can please lead us in the recitation of the Nefresi. Present my sister, they would defend it. And they could throw them in the Guam If I could ask Senator Uggan, please, to lead us in the singing of the Guam hymn, and then Senator Ada in the national anthem.
Gloria,
Thank you very much. And the clerks, please take roll call.
Senator Tom Adda.
Present.
Senator Tony Adda.
Good morning, President.
Senator Uggan. Vice Speaker Cruz. Senator Duenas. Senator Limtiaco. Senator McCready. Senator Morrison. Senator Munya Barnes. Senator Respicio. Senator Rodriguez. Senator St. Speaker Wampat. Senator Yamashita. Madam Speaker, there is a quorum.
Recognized for the approval of the Legislative Journal.
Thank you very much, Madam Speaker, and good morning. Madam Speaker, I move that we approve the Legislative Journal dated December 9, 2014, subject to correction.
On that motion, no objections, so ordered.
I move that the communications and petitions be appended to today's session journal.
Hearing no objections, so ordered.
I move that the messages from Imagalan Guahan also be appended to today's session journal,
Hearing no objections, so ordered.
as well as reports of standing committees. I also move for the same.
Thank you very much. On that motion, no objections, so ordered.
Thank you. There are no reports of select committees. I move that Resolution 513-32 COR and Certificate numbers 215-32 COR through Certificate number 217-32 COR be given its first reading.
Hearing no objections, so ordered.
Madam Speaker, I move that those senators not currently yet present for this session, I move that they be excused.
On the motion, no objections, so ordered.
I move that all resolutions or certificates of commendatory and congratulatory nature that's introduced for the duration of this session, that they be approved, and that the sponsor work with the clerk and the legal counsel in the preparation of these documents, as well as having all members of this legislature co-sponsors of those documents.
On the motion, no objections, so ordered.
Madam Speaker, on legislative concurrence, may I proceed?
Yes, please.
Thank you. Item number 1 is pending committee report. Item number 2 on the agenda is pending a committee report, so I'll move that when the committee report's filed. Item number 3 on page 4 of the session agenda, I move from the Committee on Health and Human Services, Health Insurance Reform, Economic Development, and Senior Citizens on the nomination of Dr. Gregory Miller to serve as a member of the Guam Board of Allied Health Examiners with Senator Rodriguez's committee's recommendation to do confirm. I move that be placed in the voting file.
Hearing objections, so ordered.
From the same committee with the same recommendation to pass, to report out on the nomination of Linda Rose P. Paris to serve on the same board, the Guam Board of Allied Health Examiners.
No objections, so ordered.
From the same committee, on the same, to report out the nomination of Thomas C. Babauta to serve as a social worker, member of the Guam Board of Social Work with Senator Rodriguez's committee's recommendation to confirm. I move that be placed on the voting file.
Hearing objections, so ordered.
And then for items 6, 7, and 8, we're also waiting for the committee report, as well as 9, 10, 11, and we can always go back once those committee reports are filed.
Yes.
Thank you,
Thank you.
Madam Speaker.
Thank you very much. We are on the second reading, and the first bill on the agenda is Bill number 22432 by Senator Tom Addett, primary sponsor. Bill 224. Senator, you're recognized.
Thank you, Madam Speaker. I move that Bill 224-32, as substituted by the author and as further substituted by Committee on Rules, be placed in third reading, and I would like to discuss it.
You may proceed.
Thank you, Madam Speaker. First of all, I'd like to start off by giving some background on Bill 224-32. Bill 224-32 is an act to amend Articles 9 and 12 of Chapter 5, Title 5 Guam Code Annotated, relative to amending the legal and contractual remedies in Guam's procurement law. Guam's procurement law was initially adopted on December 29, 1982 by Public Law 16-124. This law is patterned after the Model Procurement Code approved by the American Bar Association in 1979. The procurement process starts when the government issues a solicitation for supplies or services and concludes with the selection of a vendor to provide the requested services or supplies. This would be the front end of the procurement process. The process anticipates disagreements may arise due to unclear specifications or perceived unfairness. Legal remedies must therefore be provided. This would be the back end of the procurement process. Bill 224 focuses on the back end. Now, the procurement system is intentionally created to outsource the real-time policing of the procurement process to the private sector by way of protests. However, the only way that the procurement process will remain effective is if the review process is as expedited as the original procurement process itself. Updates to the Guam's procurement law. Between 1982 and today, a span of about 32 years, some piecemeal amendments have been made. Bill 224 and other reform bills to follow will take a holistic approach in the reform of Guam's procurement law that was enacted 3 decades ago. Bill 224, introduced in November of 2013 and preceded by months of efforts to develop the bill, aims to make amendments to 15 of the 19 code sections in Articles 9 and 12 of Title V GCA Chapter 5. In drafting Bill 224, we proceeded with the understanding that the structure of the remedial scheme, the appeals and protest is sound, but is in need of some changes. From 2006 to 2012, when the public auditor was mandated by Public Law 28068 to take over the appeals process, the public auditor's office has had 88 appeals brought before it, averaging approximately 15 appeals a year. In the decisions that the OPA rendered in those appeals, as well as others taken to the court system for further adjudication, many lessons were learned about our procurement code. Bill 224, in a comprehensive effort to improve the entire protest and appeals process, attempts to use those lessons learned and improve the procurement, protest, and appeals process while keeping its basic structure intact. With regards to opportunities for public input, first of all, I want to fully disclose that this bill was not formulated solely by the staff in my office. I certainly had a lot of assistance from Attorney John Brown, who basically is normally referred to as the procurement guru, one of the procurement gurus on island. And he teaches the course in procurement up at GCC. I took his course. We sat down and we took a look at how we can bring reform to the procurement process. And he has certainly given a lot of his time to assist me in the more technical aspects of the bill. Now, just a chronology of the bill itself. The bill was introduced on November 2013. It had 2 public hearings, one on December 2013 and another on March 6, 2014. The bill also had 4 round-table discussions, one in April, one in July, one in September, and one in November. Testimonies were received from the Attorney General's office, from the Office of the Public Auditor, from the Chairman of the Procurement Advisory Council, from GSA, from the Legal Counsel of the Airport, from GDOE, from the Gov Guam Retirement Fund, and from private sector attorneys John Brown, Tom Fisher, and Jessica Toth. Bill 224, as introduced in November of 2013, began taking on new shape by starting with the AG's testimony and incorporating the recommended changes, followed by the incorporation of recommendations from the OPA, from GSA, and other testimonies that were received. Clearly, there were recommendations from the participants that were not incorporated. For example, there was a recommendation that a bid protest bond be required when filing a protest. It should be noted that the bill, however, establishes disincentives against the filing of protests that are frivolous or have delay as the primary objective. There was also the recommendation that the time limits for filing a protest should be kept as jurisdictional versus being subject to equitable estoppel. The current law requires that if a bidder or a person who believes he's been aggrieved is going to file a protest, he has 14 days. 14 days regardless of what's happening in the interim. A good example is that GSA and the aggrieved party may decide to sit down and try and work things out, and at the same time, while that's going on, the clock continues to tick. And then on the 13th day, they realize we're not going to reach an agreement here, and by then, it's the time left to be able to put together a protest has elapsed, and then the protester is basically out of the game. So by changing it from jurisdictional to being one that is subject to equitable estoppel, basically recognizes that there may be circumstances, legitimate circumstances, that would merit the extension and to be able to then file a protest beyond that 14 days. There was also the recommendation to not impose an automatic stay on the performance of a contract lest the decision be ripe for a breach of contract litigation. And the argument that was made was that if we put a stay on performance, it's going to slow down the services to be provided to the government to the detriment of the government's ability to provide services to the general public. We recall cases like a DOE where they gave a notice of intent to award in the morning. In the afternoon, they awarded it. The next day, the awardee began performing the contract, and by the time the protest process got rolling, the project was practically finished. And so the bill went ahead and put in that the stay will also apply to the performance of that contract until at least the time frames that are made available by law to appeal, to protest, and to appeal have in fact elapsed. There was also another recommendation to delete the requirement for the Attorney General to reduce to writing its concurrence to the lifting of a stay, and instead it should be just a verbal input. Well, the AG does get involved in contracts, especially the ones over $500,000 that needs to go through the AG's office, by basically signing off and approving it. So the bill proposes that any concurrences from the AG's office really should be put in writing. Now let's take a look at just some of the amendments that Bill 224 makes. And I would only point out 6 sections that really probably have some very significant amendments. Although there are other sections that have amendments made to it, you could say it was basically fine-tuning the law, but nonetheless, I will only mention 6 sections which have significant amendments. In Section 1, page 1, under Section 5425, entitled Resolution of Protested Solicitations and Awards, the changes that Bill 224 makes is it defines who may be aggrieved. And you find that on page 2 of the bill. So it gives that definition as to who may be aggrieved. The bill also, in subsection A2, establishes time limits for filing a protest to be subject to equitable estoppel. It changes it from jurisdictional. And this was hotly contested by all the government lawyers. The government lawyers basically wanted that clarity that, you know, on that 14th day, regardless of whether a tsunami was occurring, 14 days is up and you're out of the game. And so it makes that change there on page 2, line 17. It shows there that basically the time limits are not intended to be jurisdictional, but shall be subject to equitable estoppel. In subparagraph E, that's on page 4, it deals with the requirement that the government has 45 days to make and document its decision. And currently the law, basically what happens is that if a bidder files a protest, that bidder is required to submit that protest in 14 days. But then after that, the government is really not required to respond back until it's good and ready to do so. Well, what Bill 224 does is it essentially gives the government 45 days to make and document its decision. Otherwise, if it does not make that decision, then the protest is deemed rejected and can now then be elevated to the next level of administrative appeal, and that would be to the OPA. So now it puts some kind of timeline, puts the fire under the government that when you receive a protest, you have a timeline to adhere to. On subparagraph F on page 4, it addresses the issue of the disqualification of the OPA. We've had cases where the OPA had to disqualify herself because of a perceived conflict of interest, and then it wasn't quite clear whether we had to go to the court. The court had to. Bill 224 simply says if the OPA must disqualify herself, then the chief auditor or the next senior auditor shall assume the duties of the OPA in the appeal. And of course, what normally happens in the OPA's office is they do hire an attorney to actually conduct the functions of a hearing officer. On subparagraph G on page 5, line 10, deals with automatic stays. And what Bill 224 does is it adds that in addition to putting a stay on the solicitation or the award, it will also put a stay on the performance of the contract prior to the time allowed to appeal. Now, the concern was raised again by the agencies, by the government attorneys, that this could be, real detrimental to the ability of the government to provide services to the public. And so the bill actually provides that the governor can override this stay by issuing a declaration of emergency. And if delay in the procurement is if delay in procurement is not in the best interest of the government, declaration can be made to keep moving forward. So there is actually an out in trying, when a stay is imposed, the government can step in and show that it is not in the best interest of the government, of the government, and so we need to keep moving on. Now, of course, to lift that stay, there's other people that needs to take a look at it. The Chief Procurement Officer, the Attorney General's office, and so, it is not just one person that's going to do it. There's going to be several people that will actually be involved in the lifting of that stay. On subparagraph H, on page 6, on line 21, it talks about the entitlement to cost. And for this particular section here, it now grants the OPA the authority to assess penalties to any party bringing any action deemed frivolous or with predominant intent to delay the procurement process. And you could say that this would be an alternative to requiring a protest bond. Subparagraph I, page 7, line 18, deals with finality. And basically, it says that the decision of the OPA is final unless the person appeals to the court. Administrative remedies must be exhausted before judicial relief can be sought. And what this does is, we've seen some cases. For example, there was a bid down at the port where after the port rejected a bid, the aggrieved person went directly to the court. And then the court struck it down and sent it back down to the OPA. And there was a lot of time that was lost in doing that. And so what this does now in Bill 224, the amendments that have been made, clearly specifies that all the administrative remedies must first be exhausted. The agency rejects it, it's appealed to the OPA, the OPA reviews it, makes the decision. If then the decision is not satisfactory, then the aggrieved person can then file to the court for an appeal. In Section 2, Section 5426 of the law, with respect to, it's on page 7, with respect to the authority to debar or suspend, what Bill 224 does is it makes the failure to pay employees according to wage determination laws or conditions as a base, or contract conditions as a basis for debarment. And that's a new parameter that's been put in. Section 3 of the bill, Section 5427, is the authority to resolve controversies. Essentially, an aggrieved contractor has a 2-year statute of limitation to take action against government for failure to issue a decision. On Section 6 of the bill, this has to do with Section 5480, waiver of sovereign immunity. That's on page 14. Deals with the issue of waiver of sovereign immunity, which basically means that an appeal can be taken to the court to seek judicial relief. But the important part there is that I think many of us have found that once it goes over and it's turned over to the judicial system, they have their own workload, and more often than not, the process can take a very long time. So the idea is that we want to try and expedite that as much as possible also. And so when it goes to the court, the appellant can actually submit it in whatever form either for full-blown judicial review or for a writ, and that then the court will take action. Currently, I believe the law only allows that it be submitted basically in the form that will require a full action, which is very much involved. But now what Bill 224 does is it says that the court can review any and all appeals related to lower administrative decisions, that is, appeal subsequent to the exhaustion of administrative remedies. And all appeals brought before the court, however captioned, shall be treated as special proceedings for expeditious review. So in other words, we're not so much concerned about the form that it is submitted, but that the fact that the court must receive it in whatever form it is submitted and let the court then decide at that time how to deal with that particular issue. Section 16 on page 21 is a section that basically recognizes that with all the amendments that have been made to these two articles in the procurement law, that we're going to need to make changes in the rules and regulations. The fact of the matter is that, so Section 16 gives authority to the public auditor, authorizes the public auditor and makes the public auditor responsible for promulgating regulations consistent with this act in accordance with the applicable provisions of the AAA process, which regulations shall supersede any other regulations of any body specified in Section 5131 of this chapter. So the comforting part is that actually the OPA has been proactive. They have stepped forward. They have been following the amendments being made that Bill 224 makes. They've actually got the rules and regulations in place. Now they've got to go through the process of the AAA, and then that would bring closure to the amendments, to the amended aspects of Articles 9 and 12. And so given that final piece that needs to be put in place, this act on Section 17, it reads that this act shall be effective 180 days after enactment, but shall not apply to controversies that have been filed or administratively or judicially appealed prior to the date of the enactment of this act. So that, ladies and gentlemen, is what Bill 224 is about, and I would just ask my colleagues to favorably consider this particular bill. Thank you.
Sorry. On the motion, Vice Speaker, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I'd be remiss if I didn't stand to commend the author of this bill for his persistence and his diligence in this. As you might know, since I first came to the legislature 10 years ago, I have introduced several bills on attempting to amend the procurement statute. At the beginning of this term, this legislature successfully passed a piece of legislation that required procurement education and certification as a basis upon which individuals within the government of Guam would have to have certification by 2017 in order to participate or be involved in any procurement. And I have to commend the author of this legislation for being one of the first ones to sign up for that course that was taught by Mr. Brown and Mr. Jerry Paris up at GCC, and thank GCC for stepping up to the plate immediately and setting up the system, or at least the classes at GCC to train procurement individuals throughout the government of Guam. As a result of him taking the class, the author of this legislation has gained, actually probably should take the mantle of guru of procurement in this legislature, and in the next legislature has thankfully decided he's going to take over the responsibility of overseeing procurement. But the thing is, Madam Speaker, is I want to also thank everybody involved in this process. As the author has listed, this has been a long process. It was introduced over a year ago, and we started our first hearing 1 year ago this month. And we've had subsequent hearings. I think we must have over close to 20 hours of hearings in this case. Not only did we have 2 public hearings in December and in March, but we had 4 roundtables. And besides the roundtables, I have to thank the Guam Bar Association for allowing us to, or at least allowing me to submit to it the bills in its various early iterations to be published in the listserv of the Guam Bar Association, trying to get members of the Guam Bar to comment on this bill. I think at least 3 times after the roundtables, I've sent out copies of the bills in their 2nd, 3rd, 4th, 5th iterations for comment by the Bar Association. So and I'm really encouraging my colleagues to vote in favor of this bill, when this is passed and this goes into effect, the Bar Association really has no one and cannot complain about the fact that they weren't involved or asked to be involved in this. At each of the roundtables, we listed on listserv an invitation to attend the roundtables. And we've thankfully had many attorneys who were involved in procurement to come and provide testimony. And so this bill was not something that was hastily thrown together. As the author put it, it was written by someone who knows about procurement. And actually, there was a companion bill that was introduced with this. It was 246. Because of the number of roundtables that this bill was getting, 246 really took the back burner. So he's going to have to take that up in the next session as one of his main projects, and probably have to go through the same number of roundtables. So I just wanted my colleagues to understand that this bill has been thoroughly vetted and commented on by the Bar Association. And those that didn't comment have only themselves to blame, because it's not as if they weren't asked. It was on listserv in the Guam Bar Association with a notice from the President of the Bar Association saying that my committee was asking for comments and was soliciting for their comments. And I did receive some comments. I wished I had received more. I actually even took the liberty of personally sending it to certain attorneys who I knew were involved in heated procurement cases, asking for their input on whether or not this could have addressed some of the concerns that they had. I received some comments, but I don't believe that I had as much as I would have loved to have received from them, since they were involved in extensive litigation. But it wasn't for not trying. We contacted everybody that we possibly could, and this piece of legislation is a piece of legislation that I think we can be proud of, finally getting through this legislature, an amendment or a partial amendment to the procurement law, and moving forward in trying to improve procurement within the government of Guam. So I think it's great that at the beginning of this session we passed the procurement certification law, and hopefully at the end of this term we now are passing amendments to the procurement law. And I want to thank this legislature for its assistance and support in trying to improve procurement, because it really is imperative. Madam Speaker, you know that in a couple of projects that you've wanted to undertake, it's been the procurement process that has been the nemesis. And so until we finally get this under control, we will continue to be plagued by procurement problems, not having projects that we'd like to see go through. So I want to thank the authors for their foresight in introducing this legislation, and for everybody that participated in all the roundtables. Thank you, Madam Chairman, and I'm hoping for unanimous consent.
You're welcome, Mr. Vice Speaker. Senator Yamashita, you're recognized.
Thank you, Madam Speaker, for allowing me to speak on Substitute Bill 224-32. While I actually remember many of the roundtables and the public hearings, I remember the procurement issue not just in this term but in the previous term, the significance and the importance of the procurement process being raised by the Vice Speaker and by Senator Tom Atta. And understanding that there has always been opportunity, there has been a message forwarded me, and if the author would yield to a concern that has been passed my way, I would like to share this concern to see if he would yield and address it. Madam Speaker, this is relative to Section 5480 on page 14, and the concern being raised is removing the words "over an action." That is being now said that it removes the jurisdiction of the Superior Court to apply the rules of civil procedures. The Supreme Court has determined that the term action means a civil action. This is important for both contractors and the government. If for some reason evidence was not preserved at the lower tribunals, agency, or OPA, the court could employ the discovery rules. For instance, neither the agency nor the EPA had the authority to subpoena non-governmental parties. If non-governmental parties had evidence that would make the procurement record complete or address the issues related to protest, only a court with jurisdiction can order such persons to be disposed to respond to interrogatories. Removing the Superior Court civil action powers as granted by the Guam Rules of Civil Procedure does in fact call to question the integrity and transparency of the procurement process. It is very important that the court have the ability to review all possible evidence. A writ does not allow the court to involve the discovery rules under the Guam Rules of Civil Procedure. This amendment cannot and should not be allowed to be made. Removing the court's ability to employ the civil rules is a violation of due process of the parties, most especially the government of Guam. And this particular community stakeholder goes on to say that subsection D should remain as is. Madam Speaker, I am simply representing this concern. Certainly procurement is not one of my strengths, but I am always a voice for those who are representing. And I do acknowledge there have been many opportunities. Perhaps this has been already raised, but for the record, if the author would yield to say how it's been addressed, if it's going to be addressed, if this is a concern or if it's not a concern. Thank you, Madam Speaker.
Senator Atta, do you yield to the question?
Madam Speaker, I think the concern that has been raised really is not an issue, because if you go to page 14 starting with line 28 in section 5480, the deletions that have been made are really some of the more specifics about the jurisdiction of the court. But basically, the amendments that were made simply says that the Superior Court of Guam shall have jurisdiction to review any administrative decision or determination arising under Section 5425 of this chapter after appeal to the public auditor. Now, my understanding of that particular language is that when the court receives an appeal, it should not be limited by form rather than the substance of the appeal itself. And so I believe that the amendment that has been made really just broadens the ability for one to be able to go to the court to seek judicial review. And I don't think we have really in any way limited the court or the appellant to be able to seek an appeal. The Superior Court shall have such jurisdiction in actions at law or in equity, and whether the actions are for monetary relief allowed under Section 5425 or injunctive, declaratory, or other equitable relief, and whether the matter is procedural or substantive in nature. So Section 5480 is simply saying the court has jurisdiction to review any administrative decision, regardless of what nature it comes in on. I mean, let the court deal with the form, but it should not throw out an appeal based on form as opposed to the substance of the appeal. And maybe, I think maybe if the Vice Speaker...
I'm not going to be giving any advice, but I will say, Madam Chairman, Madam Speaker, that when we struck action in line 32 on page 14, as the good author put it, those were all kinds of specific things that we thought we could just delete and just say very simply, the court has jurisdiction. And then we left the line in that said, left in the words that everybody was concerned about, and over in action. Because on line 4 on page 15, the Superior Court shall have jurisdiction in actions at law or in equity. So it's both that are there. And whether the actions, again, we've mentioned again the word actions, and we purposely made sure that actions was left in there. So that concern has been addressed.
So, Senator, then are you satisfied with the answer? You're welcome. On the motion, are there any other speakers? Senator Respicio, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I just want to generate some more discussion on an issue that the previous speaker brought up. I know that the sponsor of the bill and the oversight chair tried to clarify, but maybe we could take a minute recess, because the sponsor did say in his opening that he worked very closely with many individuals to put this legislation together. And my understanding is that those individuals that were responsible to give the kind of guidance that we need in this case, they're not entirely comfortable with Section 6 of this bill, which begins on page 14. And so my understanding is that if we were to leave this section as presented, we would limit the Superior Court's involvement to basically just a writ. We know that the public auditor doesn't have the power of discovery and other processes accorded to an individual by way of due process. And so if we're just saying that the Superior Court shall have jurisdiction over something after an appeal made to the public auditor is adjudicated, the public auditor's role is not the same as what a role would happen if the Superior Court had entire jurisdiction over these procurement appeal processes. And so the consensus from those that are in support of this bill is to leave this section of law out, but I don't want to do anything unless we take maybe a minute recess and consult with all parties concerned.
Okay. We're going to take a recess then, a brief recess. The legislature is back in session. Senator Ada, you're recognized.
Madam Speaker, I'd like to ask that we just pass on this, keep it in place.
We'll set it aside then. Set aside rather than pass.
Set it aside while we're sorting this thing out, and then as soon as it gets sorted out, we'll come back to it when it gets sorted out.
Okay, so on that motion, then no objection, so ordered. Thank you very much, Senator. On bill number 293, Senator Morrison, you recognize.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill number 293-32 as substituted by the author on the floor in the third reading file. I'd like to speak on it.
There's a substituted version?
Yes, Madam Speaker.
Okay, so let me get it. Sorry, because I don't have it.
I believe it was just circulated.
No, you give me. Okay, Senator, none of us has the substituted version, so we're going to take a brief recess for copies to be made for everyone. Is that okay? No, thank you. The legislature is back in session. Okay, can you please start with your motion, Senator Morrison?
Thank you, Madam Speaker. I'd like to move to place Bill number 293-32 as substituted by the author on the floor into the third reading file, and I'd like to speak on it.
Okay, so so then it would not be placed to accept it first because it's a substituted on the floor, and then we would do a placement. So the first one would be to accept the substituted version by the author on the floor. No objections so ordered. And then your motion, which is now to place substituted bill by the author on the third reading file, and you may proceed then.
Thank you, Madam Speaker. Madam Speaker, Bill 293-32 was introduced to help address serious issues raised by constituents and government agencies, such as DPW and GVB, regarding what appears to be unregulated political signage activity on government property. This legislation builds upon the efforts of the 31st Guam Legislature that established Public Law 31-148 that reduced the size of political signage authorized to be posted on government property. Some of the issues, Madam Speakers, that have been raised are safety issues, such as areas and roadways that create safety hazards for joggers, bicyclists, even those pedestrians or vehicles, motorists that just pull over to the side. There's been numerous, as mentioned by the DPW director and highway safety, that they've continued to still locate rebars that were left after the taking down of these political signs. The goal also, Madam Speaker, of 293 is to reduce the duration of how long these political signs stay on government property. Madam Speaker, I'm also part of this problem as well, and I'm not here to point out any one of my colleagues or any of those candidates that participated in this election process or previous election process. So that's not my goal here. I'm not trying to point out anybody. I think the goal is to address some of the concerns out there that some of these signs stay out there pretty long. Some of them stay out there for almost a year. And this happens every 2 years. It's either a senatorial race with a gubernatorial race or a senatorial race with a mayoral race. We're going to see this in the next 2 years. But if you look at the current existing law, it allows for a candidate to put out their sign, I believe, on July 2nd, or even June, actually, I believe June 2nd, and then you can actually keep it out there even before you even file your candidacy, officially file your candidacy, and you can leave it out there for a duration all the way to after the election. So if you look at that, Madam Speaker, that's practically almost the entire year that people have to tolerate political science. We've seen it become at a level where it's become cause aesthetic problems with areas that I used to not see signs in some areas that used to be scenic routes throughout the island. So I think it's becoming an issue as far as the duration. Madam Speaker, this bill is not intended to target how much signs as what was put out there. I want to clear that up, that we are specifically trying to address some of how we could actually get our candidates that participate in this process to responsibly put up these signs and take them down at a timely manner. Some of the solutions, Madam Speaker, in the substituted bill requires the campaigns to list detailing the location of political signs. But again, those are some of the solutions that I think were brought up by the Department of Public Works Director, which I don't necessarily agree with, but I want to put that out there for the record. that they were putting that recommendation on the table. To reduce the political signs that may be posted before a primary or special election from 90 days to 60 days. And to require campaigns to pay $25 fine per day per sign for failing to remove signs within 48 hours after receiving notice of violation from the DPW or the village mayor. So, Madam Speaker, this section allows at least the candidate some ample time to address some of the issues that may happen within a 48 hours time. So it's not given that authority or flexibility for DPW to right off the bat notice a violation and that we have to pay a fine immediately. So we do have 48 hours to address or correct the issue with DPW. It also requires a candidate who, in advance to the general election to remove their signs, who doesn't advance to the general election to remove their signs within 15 days following a primary election, or else be fined $25 per sign per day. It requires that all fees, this was recommended by the Department of Public Works Director, to be deposited as fines and collected relatively to the political signage activity to be deposited into the public rights-of-way account of the Territorial Highway Fund. This is a fund that's already in existence, Madam Speaker, and that's where many of our deposits already go to. So, Madam Speaker, I just want to make it very clear. I read some comments that kind of make it seem like this legislation is intended to target candidates in a way where it will hinder them the opportunity to get their messages across. I think 60 days is prior to any election is a lot of time for folks, especially in an island of this size, to see your sign more than 100 times, possibly throughout that time period. But I think the intent here is to address the concerns of how long they stay out there, give some authority to DPW to incentivize, also have the incentive to go out there and help candidates address their issues, and also know that they'll have the ability to fine us if we don't address those issues within a 48 hours period. So, but before I proceed to close, Madam Speaker, I'd like to make an amendment, Madam Speaker, to page 3. And to strike line 24, item 7 in its entirety.
On the motion on page 3, lines 24 to 28, which is section 7, and it takes you on to page 4, line 1 to delete in its entirety. No objection? So ordered. Thank you, Senator.
Thank you, Madam Speaker. I also have another amendment, Madam Speaker, to page 4 on line 3. Oh, I'm sorry, line 4, to strike 30 days and to insert 60 days before any special or primary election.
How many?
60.
So it'll be 60 rather than 30. Okay, on the amendment then on page 4, line 4, to delete 30 days to 60 days. No objection? So ordered. Thank you very much, Senator.
So, thank you, Madam Speaker.
On the motion, is there anyone who would like to speak? Senator Respicio, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I certainly rise in support of the bill. I just have a question if the author would yield. Just for purposes of clarity here, when we talk about removing a political sign, we should also talk about the rebars and wires that are used to support those signs. And so I know it's the author's intent to make sure that this is a complete removal. And so on page 4, line 28, after the word political sign, I would like to add the words including rebars and wires where applicable. Maybe it's already covered, but I want to ask the author if an amendment like this would make it more clear that it's not just the sign that they have to remove, but it also is the rebar and the wires. And so he's signaling that he's okay. And so...
Say page 4, but can you tell us where?
Yeah, so I guess it starts off with line 25. After the word, so the sentence reads, of $25 per day per sign for each day, a sign, and I like to add in the words, including rebars and wire, comma, where applicable, comma. And then again, on line 28, the new sentence will read, failure to remove any political sign, including rebars and wires where applicable.
Okay, because that's, what if it's from a previous...
And if this amendment passes, then also on the definitions, I'd like the legal counsel to incorporate that into the definition.
Okay, so on the amendment, I have Senator Mike Nicholas and Senator Mike Limtiaco. So Senator Nicholas, you're recognized on the amendment, the Respicio amendment.
Thank you, Madam Speaker. It actually ties into an overall concern I have with respect to the entire bill. But like, for example, this particular amendment, Madam Speaker, let's say, there's 4 signs in a 100-foot strip, and all 4 signs are removed, but only one set of rebar and wire is left there. How do they know whose rebar and wire it belongs to, and how do they know who to fine in the event that there needs to be a fine assessed for that rebar and wire not being taken away? And that's just one potential problem that I see with respect to the entire construct of the bill. How do we go about identifying those materials that are used generically throughout the sign process when there could be that rebar and wire could have belonged to anybody's sign? How do we know who to fine at that point? I guess it's a question.
Are you framing that into a question?
Yes, Madam Speaker.
Senator, do you yield to the question, Senator Respicio?
I really don't know how I would provide an answer to that very valid question, Madam Speaker, but I imagine that when we start removing our signs from the roadways or from government properties, that DPW somehow goes around and would, in order for them to return the deposit that was made, they would go around and they probably will notify the candidate and ask and inform the candidate that they believe that this is an area where their sign was and there's still rebars and wires, and anyone who's told that rebar wire may be theirs, I think because of goodwill, they would just go and remove it. But I think the biggest perennial problem that we've seen for decades since the beginning of where we had elections here on this island, people remove their signs, Madam Speaker, but they don't pick up the rebar and they don't pick up the wire. I mean, it happened in front of my own house. Of course, it's a private property. Our cousin owns the property in front of ours. When those signs were removed, they didn't think to take their rebars and their wires with them. So, but that was removed because it just had to be. But in this case, I think candidates should know that their responsibility extends to not just removing the political sign because they can be traced back that it's theirs. I think they should also make the concerted effort that if their sign was in that general area, that they do a clean sweep, and even if those rebars or wires aren't theirs, just remove it. I don't imagine Public Works going and finding these candidates without first giving them proper notice that they may be in violation.
Senator Nicholas, sorry.
Thank you, Madam Speaker. I understand the intent. The concern becomes, though, how does Public Works go about assessing a fine to a candidate when they cannot prove that material actually belongs to that particular candidate? We are still enacting a provision here in public law that is enforceable if it ever were to get enforced. So if there is rebar and wire remaining in a site where a sign used to be, and they're unable to identify whose rebar and wire that belongs to, how can DPW rightfully assess a fine to any particular candidate when it's not able to prove who owned or who was responsible for that wire and that rebar? And so that's the only side that I'm coming from on this issue, Madam Speaker, is the burden of proof and how do we go about making sure these fines are properly assessed versus the wrong person or the wrong candidate getting assessed a fine for a mess that doesn't belong to them.
Madam Speaker, I rise to a point of information.
Yes, please state your...
Thank you, Madam Speaker. It goes back to an earlier point I made beginning on line 22, where it says a sign not removed within 48 hours of notification may be removed immediately. So the candidate is notified. So if you're notified by Public Works that your sign may be in violation because the rebars and wires are still there, you certainly can either tell Public Works that you don't believe that's your rebar or wire, or you could simply go and remove the rebar and wire. But there is a notification process, so they're just not going to go and assess the fines of $25 per day. The candidate will be notified, then they have 2 whole days to go and remedy it. And if it's faster just to go remove the rebar and wire than to say, oh, that's not my sign, you shouldn't fine me. I mean, let me know where those rebars and wires are and I'll go and remove it. It's that simple, Madam Speaker.
Senator,
no, I totally understand the concept, Madam Speaker. The point is that it's a provision of law, and it's enforceable. And anybody can go and remove the wire and rebar, what have you. But the point remains that if the department of the agency is able to find somebody for that wire or that rebar, then we need to make sure that that person is being properly fined. I mean, just because we're going to say, it's so much easier to go do it this way, it is. It really is. But the bottom line is we're creating a provision of law here that's enforceable, or that we would like to be enforceable. I mean, are we just creating another provision of law that we're just hoping happens because everybody wants to follow it, but is not necessarily getting enforced? And that's the overall problem that I actually have with this bill, Madam Speaker. We already had sign laws in place that weren't enforced in this last election. And to create a whole new piece of legislation that's going to tighten the law that's not being enforced, I think is skirting the issue of whether or not laws are getting enforced at all. But not speaking to the overall bill, but strictly remaining to the amendment, Madam Speaker, is again, if we're going to be identifying a certain item that needs to be enforced in the law, then we need to make sure that it actually is enforceable. I mean, how do you go and find somebody for wire and rebar when you're not able to identify whose it is? And the section there that was referenced with respect to the 48-hour notice is only for subsection H, the removal of signs that has to do with the violations of the provisions of subsections B, D, E, F, or G. So if the election ended and you have X number of days to remove your signs, it has nothing to do with the violations and the 48-hour notice. The 48-hour notice will only be if there's an actual violation. But if you're just removing your signs in the normal course of business because the election's over, you have so many days to do that. And we've seen how many there are. How do you go about thereafter assessing a fine on somebody when you're not able to truly identify or prove that rebar or wire belongs to that individual? And that's the only point, Madam Speaker. Again, it has to do with making sure that we're enacting laws that are actually enforceable, and that there's an adjudication mechanism by which the person who's being assessed a fine can say, hey, you know what, that's not mine. I mean, yes, anybody can go pick it up. Yeah, I can go drive around, or we can call whoever to go do it for us. But the point remains, if we're going to allow for an agency to find somebody, then we need to allow for that law to be enforceable to its truest intent. Not just to say it's a good idea and that's why we're going to put it in here. If we want it to be enforced, it needs to be enforceable. And that's my point on the amendment, Madam Speaker.
So will it help if it was including rebars and wires attached to the sign? Then I make it as one whole package.
Of course, Madam Speaker,
Yeah.
but the point of the amendment was, let's say that there's a remaining wire and rebar on the ground. Who's responsible for that? How do we go about assessing a fine for that? And so, if we're going to be getting into that, which I think is fine, we just need to make sure that we're able to actually identify who gets fined for that. But yeah, if you want to say attached, that's perfectly fine. But if we're going to be creating a mechanism by which we can be issuing out fines to any individual, we need to be able to make sure that we can prove that those fines are being properly assessed. That's all.
Okay. Thank you very much, Senator. So, I mean, you didn't state whether, you're just speaking, not necessarily deciding whether you're for or against the amendment yet.
I am, because we're not able to identify, at least the way the law would be written, aside from some of the other provisions in here, that we're not able to identify or not requiring the identification of who owns the item that the fine is going to be assessed to. I mean, it's like saying that we're going to be fining somebody for littering, but we don't even know who actually littered. You know, and if we're going to say, well, you know, but just call me and I'll go and I'll pick it up. Well, yeah, sure. But you need to be able to identify the individual who actually owns the item that that you're assessing the fine for. So I'll need to raise and object to the amendment on those grounds, Madam Speaker, only that it will be a provision in here that technically would be unenforceable. Or if it were to be enforced, it would be enforceable in a manner that is unprovable or can cause doubt as to whether or not it's going to be enforced properly. Thank you, Madam Speaker.
You're welcome. Senator Mike Mchako, you recognize.
Madam Speaker, if the author of the amendment would, my concern is that it may not be regulated to just rebar and wire. So, I would proffer an amendment to the amendment unless the author would just like to change the language to the amendment to put all items associated with the erection or the securing of the sign, because it wouldn't be specific to rebar or wire, depending on how they choose to fasten it. I've seen some recently with zip ties, etc. But just to make it comprehensive, it would be all items are used in the erection or securing of the sign.
So be all items. Okay, we're going to have to, of course, make a motion to delete his amendment, then to accept your amendment.
Yeah, or the author can just amend the language accordingly.
Okay, why don't we take a brief recess?
Thank you, Madam Speaker.
The legislature is back in session. There's a suggestion to incorporate Senator Respisio's amendment by Senator Mike Limchaco. And if I have the words that you had in your amendment, is that all items in the erection and securing of the political sign, including rebars and wires. Including rebars and wires. Okay, is that acceptable then to the members? Okay, so then, all right, so then there's no objection to that. And one more time, I would read all items in the erection and securing of their political signs, including rebars and wires, which incorporates Senator, to amend rather, Senator Respisio's amendment. And it's going to be on, yes, lines 25 after the word sign, and on page 20, line 28 also after political sign. And, to add a definition, a separate definition. So we'll consider that a technical, because on page 5 there's another. So wherever then this language would be appropriate to place, which is lines 25, 28, and I also think page 5, line 6. So on the amendment that has been amended, Senator Ogden, you recognize. Oh wait, before you do, I'm sorry, I had Senator Morrison. I listed you down that you wanted to speak on the amendment. The amendment that has been amended. And then Senator Ogden.
Thank you, Madam Speaker. I rise in support of the amendment. I thank the colleagues for providing this suggestion, because I think over time we're seeing signs and the way that we erect signs evolve, where we're using different types of items to secure signs. It's not necessarily wire, rebar. There is other items that are used to secure these signs today. So using that language, all basically covers all that. So I rise in support of the amendment. Thank you, Madam Speaker.
Thank you, Senator Morrison. On the amendment to the amendment, Senator Ogden. Huh? I know, but I thought you wanted to discuss it. Oh, okay. So on the amendment to the amendment, no objections? Well, there was an objection, even though with the amendment to the amendment. Senator San Nicolas.
Thank you, Madam Speaker. It still doesn't change the fact that it creates an enforcement question. If there's still materials, whether it's tie wires or nails or wire or rebar, that are left there and you cannot identify whose sign they belong to or which candidate, the question still remains: how does DPW fairly assess a fine when they cannot determine who actually owns those materials? So that is the only reason why I object, Madam Speaker. Perhaps another avenue that we can discuss on this issue would be to increase the permitting fees, that DPW just addresses the issue right then and there rather than trying to figure out who to fine. But giving authority to an agency to issue a fine without actually having the agency responsible for making sure they're finding the right person and not having the right mechanisms in place to ensure that, it doesn't sit well with me as far as crafting public law goes. So my objection still stands, but I do not because I disagree with the intent of the amendment or the amendment as amended, but because the manner in which we're going about having a law that's going to be enforced, that becomes very difficult, if not impossible to enforce, if you're not able to properly identify who is the person that you need to be fining. Now, that's my only objection, Madam Speaker, but that's why my objection still stands.
Okay, so since there is an objection, I'm going to call for the vote. So all those in favor of the, I didn't even ask to call it yet, and Centrada's really quick to answer. All in favor of the amendment to the amendment, please raise your hand. Okay. The amendment carries. So on the main amendment, which is the including bars and rebars, yes, because the amended version to yours is an amendment to the amendment. So now we're on the amendment. You're right. So, and you want to speak?
Yes. Thank you very much, Madam Speaker. Madam Speaker, I thank our colleagues, particularly the one, Senator Mtiaco, who amended my amendment, and also I rise to share the concerns raised by Senator Snickles, and I certainly want to allay his concerns by offering the possible following scenario. You're a candidate for public office, right? And so you put all your signs up. You complied with the requirements of this bill if it becomes law. And then at the conclusion of the election, you have 15 days to take your signs down. Well, you go around, the candidate will go around and remove their political signs, and somehow they may leave their rebar, or they may leave their wire, as another senator pointed out. There are other materials that are being used, like 2x4s and in some cases actual cement blocks to secure those political signs. The candidate for public office that somehow may have missed a rebar or wire or any material that secured their signs, if they get a call from Public Works saying, we believe that this is your rebar, this is your wire, you're going to be faced with $25 per day per sign for each violation. Madam Speaker, I imagine that there's two things that would motivate that candidate for public office to comply some way, somehow. The first is the actual fine, but even more than the actual fine is the possibility of public embarrassment. When Public Works would, if Public Works publish all the violators, I mean, that's just one more thing that the candidate would definitely want to avoid being a subject of public criticism because Public Works believed that was their rebar, their sign. Maybe in the interest of due process, which is what we always have to strive for, maybe we can also, see again in line 26, it does say it's not removed after 48 hours, so there is a notice. So the candidate will get notice that by Public Works that if they don't clear this violation, then they would be subject to the $25 per day per sign. So I believe for me this is enough for me to move forward to say that the candidate should also be responsible for everything involving for the securing of that signs, which includes those rebars and wires and other material used. So I'm very comfortable that Public Works and the candidate will be able to work through this to make sure that if there is a violation, and the concern that what if that's not that candidate's rebar. Again, if you're given notice by Public Works that they believe that that's your rebar, that's your wire, I think it's just something as simple as because your sign was in that area or proximity to that area, I think it's just something that the candidate will make sure they go and remedy that violation to avoid those two very real consequences. So I thank the senators who deliberated on this, and I certainly thank the mover of this bill, and I think that what we did maintained the spirit of this legislation by wanting to make sure that everything is removed and not just the political sign, not just because that candidate would be associated with that political sign that they want to remove it. I think what we're trying to do certainly creates a responsible community versus just trying to find someone responsible. And so I hope the main amendment as amended passes, and I certainly hope that.
On the main amendment then, that has been amended, are there any objections to the main amendment? There being none, so ordered. On the motion then to place, I have Senator Rodriguez and then Senator Toniata.
Good morning. Thank you very much, Madam Speaker. Madam Speaker, I first of all want to acknowledge and recognize the authors of this legislation to somewhat trying to address some of the issues with our political signs. However, I'm really concerned with the manner on which we're approaching this issue on several fronts. I think the first is that the purpose, as we heard the author speak about is that this is to fix the process now in terms of regulating our political sign laws. If that's the purpose of this legislation, then I think this is not the proper way to go. Some of the issues some of the concerns that were addressed here earlier, and I again recognize and acknowledge the author in terms of amending the time frame where political candidates have the ability to put out their signs from 90 to 60 and 30 and then back to 60. I'm glad we brought it back to 60, but I just feel that at least that part of this legislation is really more of a pro-incumbent type of it's for us here who already have that name recognition, or for individuals who have established their individual names out there in the community. And I think that as we see now, we don't really have that much interest of individuals running for public office. And I think if we're to encourage more people to be able to come out and run for public office, people really who are just the regular common individuals out there, I think being able to give them the opportunity to campaign early on, as early as 90 days, is something that we should be able to encourage. Sometimes for some candidates, putting up signs is the only type of marketing they could afford. They can't afford to purchase any media, any radio buys, or any TV buys, or any print advertisement. And so putting up signs is really the only way they could promote themselves. And so that's a concern that I have there. Another concern is what we've already discussed here earlier in terms of, okay, if you don't remove your signs within 48 hours, or after the time frame allotted to us now, which is, I believe, I don't know if it's 10 or 15 days after the election, you must remove your signs. You drive down the roads nowadays, I personally don't really see much of a problem. I think people comply with taking down their signs in the time frame that that we're given. But the way this a section in this legislation is written is that the mayor, Department of Public Works, shall give notification to a candidate or organization that they must remove a sign, and if it's not removed within 48 hours, then they're going to be assessed a $25 per day per sign, essentially a penalty. But then, as we all know in our campaigns, we have our organizations, we have our logistics people who are tasked to do this. But then you also have individuals, supporters out there who may, want to put up signs on your behalf and do it. And so it kind of is not part of your, your campaign's logistical plan. And so I think, who are we saying the Department of Public Works or the mayor is going to notify? Is it the candidate, or is it that one supporter that the mayor may know that one supporter had put it up? Who's ultimately going to be responsible for that sign being taken down, and who's going to be assessed that penalty? And so, and what kind of notification? Is it a phone call from the mayor, from Public Works saying, okay, Mr. John Doe, you put up a sign there. Are you need to take it down within 48 hours, or candidate Dennis Rodriguez, you need to take down your sign. Who is ultimately going to be responsible for that sign? And so I think that that needs to be worked up in terms of, is it a written notification, a verbal notification, a notification through email? I think that's some of the things that need to be worked out. But yeah, I think just being able to to assess a $25 fee, it's a lot of money for some candidates who may not have the means to to be able to pay these fines. Sure, I know the intent is take your signs down when the election's over, but as I said earlier, for some candidates, it might just be themselves. I remember when I first started, just myself, and just some family members who went out there, and for others it's just that that the candidate, and I've seen it, and that candidate's spouse that goes out there and puts up and take down signs. And so I really think that maybe the approach to this is that if we're going to be able to really give the tools to Public Works to regulate our sign laws. Perhaps, and I heard it earlier, is to increase the cost of the permitting fee and the amount of what is used as a deposit. And so then, candidates now can, right off the front end, be able to factor this into their whole campaign, their campaign budget. Now you pay $100 for to put up a sign plus $200 as a deposit, and maybe if you increase that deposit portion at least, then now the Public Works would have the tools, would have the resources to be able to enforce these, and if need be, if they need to be the one to take it down after the time frame that we've given them to take down signs is not adhered to, then there's some resources to be able to use for the department to take down these signs. And I just feel that really it's just a concern to me that we're restricting candidates, especially those who are just trying to run for the first time and don't really have their name established. I think it's just a step backwards for them most especially. Thank you, Madam Speaker.
You're welcome. On the motion, Senator, and my apologies, Senator McCready.
Thank you, Madam Speaker. I rise in support of the bill, and I thank the good senator for authoring it. But the former speaker also has some good points as well, and I hope we can address them. I just had a question when it comes to the time limit and the window of fines. So when we say in page, I think it's page number 4. On page number 4, line 24, the candidate or organization shall be responsible for paying a fine of $25 per day per sign for each day a sign in violation of this paragraph is not removed after 48 hours. So my question would be, because on page number 5, it says any political sign within 15 days after the conclusion of any general special election shall be grounds for forfeiture of the deposit plus a fine of $25 per day per sign. So does the window and the clock of the $25 start after the 15th day, or does it start after the 48th hour? Because what I'm concerned about is if a year from the general election passes and they've exceeded the 15-day mark, and then DPW finds the sign a year later, do they get charged from the 15th day, or do they start the clock from the 48th hour that they were notified? So that's my question.
Senator Morrison, do you yield to the question?
Thank you, Madam Speaker. I thank my colleague for his question. The 48 notice or hour notice will be the trigger for when they substantiate at least some evidence to when they discovered that sign was still up. So again, it's an existing law right now that 15 days is actually the threshold. So we're just working with the existing law. Now, again, the 48 notice will be the trigger to be for determining from that day on to correct it, or if they don't correct it, will be when the daily fines will take place.
So it's after the 15th day, then the clock starts towards the 48 hours. That was, I think, his question.
Right.
So
after the 48
it's like
hours.
the 17 days,
right.
In essence.
Madam Speaker, and this is kind of standard throughout the government. When you get a notice of violation or notice of things, you got time to correct it or respond to the notice. So again, I think my colleague's question is when does it take place? If it was discovered 100 days after the election, does the clock tick from that for 100 days and finding that candidate for 100 days? No, that's not the case, Madam Speaker. It will be after the 48-hour notice if it wasn't corrected.
Senator McCready, was he able to answer your question?
Yes, that answers the question. I wanted to make sure that the intention was addressed publicly. So So we know when we compile the law that the intention is to start it after the 48-hour notice of the $25 fine. That is my definition of what the answer was.
But you didn't say after, it says within line
within
22.
So
and 20 says
as long
within.
as long as the notification of 48 hours starts the clock of $25. That was the answer that was given by him, by the good senator. Thank you.
All right. On the motion, Senator Toniata.
Thank you, Madam Speaker. Madam Speaker, I see the intent of my colleagues with the introduction of this legislation. However, I do have a concern, and it's on page 5. When we start at line 1, where it says every political sign shall be removed no later than 15 calendar days after the conclusion of any general or special election, and the amended part there is or primary election if the candidate is not successful in the primary election. My concern here is that, and this happened just this past election, where a candidate was not successful in the primary, however, ran as a write-in candidate for the general. Now, if we keep this in this legislation, that will preclude anyone who loses on the primary election from actually keeping their political signs up running as a write-in in the general. If the author would yield whether he would be amenable to deleting that section, or how do we address it so that we don't leave anyone out that desires to run as a write-in candidate.
Senator Morrison, do you yield to the question?
Madam Speaker, I thank my colleague for the questions and his concern. Obviously, that took place this past election, and again, the intent was not to, again, target any specific person or anything that was not successful either in this past primary election or any primary election in the future. I think the candidate determined that he wanted to go as a write-in for the general election, and I guess the Guam Election Commission was able to authorize that as an individual that wanted to take place as a write-in. I don't necessarily see that this would, if the Guam Election Commission officially recognizes that this individual is a candidate, then that person's a candidate and is still allowed to market him or herself as a candidate in the election. So they have every right as every candidate to keep their signs up.
So, Senator Toniata was able to answer your question because he's going the route of the Election Commission certifying that they are a candidate, but then we don't know the time frame between as to when that's going to happen.
I think that's a concern there, is that, after 15 days from the primary election, if a candidate is, starts getting fined per sign per day.
We're going to take a brief recess. The legislature is back in session. Senator Toniata, you still have the floor.
Thank you, Madam Speaker. Madam Speaker, then what I'd like to do is just make it a short amendment, and it'll start after primary election on line 3. So it'll continue on to say primary election and does not choose to run as a write-in candidate. So in that way, it addresses that issue that if they do not choose to run as a write-in candidate and they lost in the primary election, then that's when the clock will tick for them, that they will go ahead and remove their signs.
So the amendment then on line 3 after election is to add and does not choose to run as a write-in candidate.
Yes.
And what about the rest then of the lines? You are to delete that?
No, it'll stay as is then.
But it doesn't, okay, well,
Yeah.
the original amendment was a technical amendment then for legal counsel to make these corrections to make sure that the sentence here runs
Right.
smoother because it's not grammatically correct. Okay, on the amendment, Senator Nicholas, on the other amendment.
Thank you, Madam Speaker. I very much agree with the statements made by the retiring speaker with respect to the amendment. And again, it's just one of the various provisions throughout this bill that for me caused me to really, have serious issues with the overall bill in its entirety. One of my concerns that I was going to raise is the very concern that was raised by the author of the amendment is with respect to the write-in candidates. But even with respect to the amendment as it's been amended, is that how do you determine whether or not the individual chose to be a write-in candidate? Is that, again, as mentioned earlier by one of the previous speakers, do they have to submit a formal declaration? And to who do they transmit that to? Is it okay to send it in by email? What if the candidate was being drafted, And we've seen this problem in the recent election where individuals were saying that they wanted to run as a particular candidate in a particular party, and they were being told that they were not, going to be recognized as such. And so I just want to make sure that even if we're going to be allowing them to choose or not to choose, how do they go about having that protection of being able to say, you know what, I did state that I wanted to continue my candidacy as a write-in, and this was what I submitted. And what satisfies that submission? Is it the Guam Election Commission? Is it just simply sending in an email to the director? What if the director didn't read his email? So those are just some of the other concerns that are associated with this. But I do agree with the underlying intent of the amendment, which is to afford write-in candidates the opportunity to be able to keep their signs up going into the general in the event that they didn't make it into the primary. But whether or not the change in language there that just says if they choose to, provides the necessary protections for that candidate in the event that someone were to say, no, I didn't receive any word from you, how do they go about validating that they elected to exercise that option? So again, Madam Speaker, it's just another concern that I have with the overall bill as it's been written by the author. So I guess that would be a question. How do we validate that they've initiated or they've exercised their option to choose to run as a write-in candidate?
And who would you like to answer your question?
I guess to the individuals proffering the amendment.
The mover of the amendment, Senator Toneda.
Thank you, Madam Speaker. Madam Speaker, with when an individual runs as, I believe, as a write-in candidate, they do notify the Election Commission that they'll be running as a write-in. So once that notification goes to the Election Commission that the individual will be running as a write-in, then they should be able to, that should be able to say that they're actually a candidate for the general election again. Yeah.
Senator St. Nicholas, was he able to answer your question?
Yes, I see where it's going. So I guess that would require a letter to the Election Commission, or if they were to choose to run as a write-in candidate, if they were to choose to run as a write-in candidate and thereafter notify the Election Commission. Exactly how does the write-in candidate go about saying, no, I told you that I'm going to run as a write-in? Versus DPW saying, take all your signs down because you're not running anymore.
I think we're going to need to verify with the Election Commission office whether there is a requirement to register to be certified that they're running as a write-in candidate, because I know always on the bottom of every candidate there's always a line for a write-in. So therefore...
And again, Madam Speaker, it's not that I disagree with the amendment. I support it. I just want to make sure that if the individual does choose to run as a writing candidate, as we're stating here, how do they go about having the evidence to prove that they elected to exercise that option? And in the event that someone were to say, no, you didn't notify anybody, we're taking your signs down, how does the candidate actually have those protections in place?
Yes. So I guess what we're going to do, since it is 12 o'clock, is that we're going to recess and we're going to have the author call Election Commission office to clarify, that particular question, whether it should be added on as an amendment to the amendment, is whether the candidate who is not successful wants to run as a write-in, do they need to submit a letter to the Election Commission office, or can they just do this on their own? But that's the language now that would be considered as an amendment to an amendment. Okay, so we're going to recess until 2 this afternoon.